All right, next we are going to look at Orr v. Trump. Now, this is a case about a Trump policy that required new passports to reflect the applicant's sex assigned at birth. Now, this is a policy enacted by the State Department in response to an executive order. But if you haven't noticed, the executive orders have been written to be intentionally a little bit vague, so they don't risk being overturned by the Supreme Court. So most of them, if you look closely, don't really say anything at all, and that's intentional. Now, the exact wording on this one is that the State Department should, quote, implement changes to require passports to accurately reflect the holder's sex. Accurately reflect. Okay. Which the State Department says left them no choice but to change this policy. And so they've appealed a lower court preliminary injunction and asked for a stay pending that appeal. One of the main questions here is whether or not they violated the Administrative Procedures Act, which lays out the process that agencies have to follow to change their rules. The State Department says they didn't violate the APA because this was an order directly from the president, so they didn't change any rules at all. He did. But the district court disagreed, and the lawyers for the president didn't really argue because they don't want this EO to be the source of the change either. That puts the president right in front of the Supreme Court where he does not want to be. So the Court of Appeals took a look here and said, nah. First, the EO was a little vague. Even the president's lawyers seemed to think so. The State Department had to interpret for themselves a bit, so they should have followed the APA when they did. Also, just because it comes from an executive order doesn't mean it gets to skip the APA either. Nice try. So the stay is denied, but it still has to go to the Court of Appeals for a real hearing, and this is only the preliminary injunction. The actual case hasn't even been heard yet, so we're still in preseason here.